podcast is provided for informational and educational purposes only and should not be construed as legal advice. Because every situation is unique, you should consult with a qualified legal professional for advice specific to your circumstances. If you need legal guidance, please reach out to an accredited attorney or contact us to schedule a consultation. Hello, and welcome back to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. Today, we are going to be going through the anatomy of a rating decision. I know it can be kind of confusing when you receive mail from VA and there's a lot of information in there and they're telling you a lot of things about your claims, and some of the stuff is important and some of it's just sort of cookie cutter language. And so trying to understand and parse apart what is in the rating decision and what to look for to understand why VA might have given you a specific rating, or what you can glean from a denial and what's going to help you understand better what your appeal options are. The rating decision comes with a notification letter on top, but the piece that we really want to dive into is the rating decision itself. And that's the one that starts off, the top of the page has the seal of the Department of Veterans Affairs. And then it says Department of Veterans Affairs, Veteran Benefits Administration, Regional Office underneath it. So that's the one, and we're going to put this up on the screen so you guys can kind of see exactly what we're talking about. That's the one that we're talking about that I want to pick apart with you guys and help you understand what you're looking at. So right underneath that, you've got the veteran's name. It should be your name. Occasionally, VA will put the wrong letter in an envelope. So if it's not your name, that's a tip right there that something's off, but it should be your name. And then it says VA file number. And for most veterans, that file number is your social security number. For some veterans that served Vietnam era and earlier, there's a separate number that VA issued that's not your social security number. But for most of you guys, it's going to be your social security number. And then it says represented by. And so if you were represented by a VSO like DAV or VFW, or if you're represented by an attorney, it will have that information there. If there's no represented by, then you know that you filed the claim on your own. But that kind of tells you who you're working for, who filed something for you, who's still on file with VA at the time that you got this decision. So for some people, that's important information. Hopefully most of you guys know that, but I know there are some representatives out there that might sign some paperwork and you're not sure if you're still working with them or not. That's going to be listed on the rating decision. And it's going to have the words rating decision and the date. And that's the date of the rating decision might be slightly different than the date that's on your notification letter. So we're looking at the date that VA made this rating decision. And then underneath that, there's a section that says introduction. And for some veterans, you can kind of skip this part, but I think as representatives, it's important for us to look through this part because there are clues here that VA might have gotten some stuff wrong. If we want to make sure that the information that they have in that introduction section is correct. So it says the records reflect that you are a veteran of, and then it's going to say what era that you served in. So on this example, it's peacetime and Vietnam era. It doesn't mean that the veteran served in the Vietnam War. It means that they're Vietnam era veteran. It will say Gulf War. It might say peacetime if you served between the conflicts. So that's kind of general information. Then it says you served in the Navy from this date to this date. So we do have some veterans, especially reservists or guards, that have multiple periods of service. We have veterans that have done some time in the Army and then some time in the Navy or Marines and Air Force, what have you. So if VA is missing dates of service on here, that's an indication that they might not have all of your service records. And so that would be a big red flag that if they're saying, well, this can't be service connected, or that, if they don't have all of your records, that's something that you want to work on appealing and getting VA to review all of your records. They are only going to put active periods of service. So if you were in the reserves for 20 years, it's only going to show those periods of service where you were activated, not all of your drill dates and all of that. So just keep that part in mind as well. And then it says, we received your supplemental claim on this date, or we received your request for higher level review, or we received your application for benefits. Sometimes VA gets the type of application wrong in their summary. I don't think that part is quite as important, but it tells you what the last appeal or application to VA was that they're making a decision on. And the biggest point here is it's really important to remember that you can't file a higher level review on a decision that was issued on a higher level review. So if you filed a request for a higher level review and VA denies it again, if you try to file another higher level review, VA is going to kick it back. So that's the biggest one there is understanding that that's kind of the one gap that you can't file. You also can't file a higher level review on a board decision. So there are some, it tells you what level of appeal this decision was issued following. So it kind of tells you where you're standing, and that helps inform. We've done other episodes on the Appeal Modernization Act. That information is going to kind of help inform what your appeal options are. And that says we've made the following decision or decisions on your claim. And then there's a big bolded underlined, and it says decision. And there's going to be a number for each condition that is decided. So if you filed for multiple conditions, VA will list multiple conditions on that decision. And sometimes you'll see that they make a decision on one and they say deferred on some of the others. So that they're letting you know that they're still working. Deferred means that they're still working on it. They haven't issued a decision, but they're going to list that usually on this rating decision and let you know that they're still working. So deferred is not a denial. It's not a grant. It's just, hey, we're still working on it. It's acknowledgement that we have that claim. We're still working on it. Then it's going to tell you what conditions and what decisions were made, but basically in just one sentence. So on this example, this redacted sample that we're going through, evaluation of non-small cell carcinoma of the lung with emphysema, which is currently 30% disabling, is continued. So I think a lot of times veterans are looking for, was it granted, was it denied? So what does it mean is continued? Continued means that VA didn't change the rating. So if in this situation, the veteran's prior rating was 30% and VA continued the 30%. So that means they didn't reduce the rating, but they also didn't increase the rating. So depending on what you were, if this is a decision that you got after a proposal to reduce, confirmed and continued is, oh, thank goodness. They didn't take away my rating. If you were going for an increased rating and they say they confirmed the current rating, that means they denied your request for increase. So they kept it at 30. We also sometimes will see the prior denial is confirmed and continued. So we denied it before. We're continuing to deny it. So that's what that confirmed and continued means. Obviously, if they say it's granted, you're going to look at the date that it's granted from, because that's your effective date, and what rating level they gave you. So it's granted at 30% from XYZ date. So that's something that you want to pick apart and see if they got the date right and if they got the rating level correct. The next one on this example is entitlement to individual unemployability is denied. So in this section where it says decision, they're not giving you the rationale. They're just listing the conditions and saying what VA decided on those claims. Then the next section underneath that is the evidence section. And this part can be very important, especially if there's a denial or a reduction, because you can send a lot of evidence into VA. I think they're getting better, especially with their use of AI in categorizing evidence and actually reviewing the evidence that they have. But there have been times where veterans are pretty sure that they sent in a private medical opinion. And then we look at this list of evidence and we don't see that list of evidence. We don't see that private opinion in the list of evidence. So that either means that it didn't make it to VA. If you gave it to your veteran service officer and they didn't submit it for you, or you mailed it in and the mail got lost, or maybe it could also mean that it's in your file, but it somehow got mislabeled or overlooked, and VA isn't listing it as evidence that was considered in your decision. So that's an error. If you have evidence that you know is favorable and it's not listed in the list of evidence VA considered, that's a red flag and could be a basis for an appeal. So the stuff that is listed, this is just kind of an example of some of the stuff. So it lists the forms that are submitted and the dates that they were received. So we have a VA form 218940, which is the VA form for unemployability, TDIU. They received that. They received the 20-0995, the decision review request for supplemental claim. It lists some of the prior rating decisions. It says VA letter concerning your claim. So that's a letter issued by VA. VA form 214192, request for employment information in connection with your claim. So they received that form, and it says there's a disability benefit questionnaire conducted by VES, which is one of VA's contracted exam companies, on respiratory conditions, and they say what date that exam was conducted. So here in this list of evidence, I don't see any personal statements. I don't see private DBQs, disability benefit questionnaires, or private medical opinions or private vocational opinions. So if that stuff had been submitted, it's not listed in the evidence, that would be error and it would be reason to justify appeal. So you're looking closely at the evidence that VA says that they considered. Just because it's listed here doesn't mean that the rating officer gave it the amount of weight that it deserved, or considered it appropriately. But at least if it's listed there, you know that VA has it in the file. The next line or the next section is the reasons for the decision. And this is the longer section. This is the narrative section where VA tells you why they made the decision they made and cites any regulations that they relied on to make that decision, and explains, at least in theory, the evidence that they relied on to make the decision that they made. So in the beginning, they often will kind of list some general regulatory guidance, the rules that they're following in making the decision. It's often less specific to your case, but it can be important, especially if you're newer to VA, to read the whole thing. But typically it's the general rules. So the evaluation of non-small cell carcinoma of the lung with emphysema is continued at 30% disabling. We have continued a 30% evaluation for your condition based on, and then it lists this is where they're kind of aligning the symptoms. So this is probably information that was in the disability benefit questionnaire or the CMP exam that lists the symptoms at a certain level that align with how VA rates stuff for 30% for this condition. When there is a disparity between the results of different pulmonary function tests, so that the level of evaluation would differ depending on which test result is used, the test result that the examiner states most accurately reflects the level of disability shall be used. In your case, the examiner indicated that the one specific test ratio most accurately reflects your level of disability. And they cite the section from the Code of Federal Regulations that gives that guidance on how they assign the rating from the disability benefit questionnaire. And then they will say a higher evaluation, and the next higher level after 30% on this one, it would be a 60% rating. But a higher evaluation of 60% is not warranted for this condition unless the evidence shows, and then they list the stuff that the rating code requires for meeting the next higher level. And so they're saying, well, you didn't meet these. If you did meet these, you would qualify for the 60% level, but you didn't, so we're assigning the 30% level. It says, we reviewed the evidence received and determined your service-connected condition or conditions have not increased in severity sufficiently to warrant a higher evaluation. So based on that, you're understanding what evidence they use. They use the CMP exam and what criteria, what specific code what specific disability ratings code in the rating schedule they used to evaluate the respiratory condition to assign the 30%, and why they think, at least that they think that the symptoms meeting the 60% criteria are not present in those records. So if you look at that and you say, well, I have records that show that I meet those criteria, does VA have those records? So if VA doesn't have those records, that might be enough reason to file a supplemental claim and get those records into VA to show that you meet the higher criteria. If VA does have those records and you think they overlooked them, then you might file a higher level review or a board appeal. So those are some of the things that we kind of look at when we're figuring out what the best avenue of appeal is in the rating decision. I want to go over the next one because the next one is really a true denial. And when you have a grant of something, you do want to look at the effective date because sometimes VA will not assign all of the back pay that you're entitled to. And you do want to look at the rating level to see if maybe you qualify for a higher rating than what was assigned. But typically you're not pulling apart the rating decision as much because you got a grant. You're happy VA gave you the benefits. So I chose an example here where VA denied some stuff so that we can kind of dig into what information you're looking for and how you're making decisions based on what VA is putting into that denial letter. And some of them are going to be more detailed than others. They're supposed to follow kind of their internal guidelines on how they write up a decision, but there's some variation from regional office to regional office and from rating officer to rating officer. So you will see some differences. So the next one, so it lists number 2, entitlement to individual unemployability, and that tracks with the number 2 from the decision. Remember in the top where they just list their decisions but don't give you the rationale. Now here they give you the rationale for each condition that they decided. So for each claim that they decided. So in this one, entitlement to individual unemployability is denied because you have not been found unable to secure or follow substantially gainful occupation as a result of service-connected disabilities. So they tell you the reason why they denied that claim. And they say you are considered capable of gainful employment. Well, that's kind of just a summary statement. So far they haven't given their reasons. And then they go into some general information. A claimant may file a supplemental claim by submitting or identifying new and relevant information, blah, 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 in support of your claim, new and relevant information. New and relevant evidence has been received and your claim is now reconsidered. So basically in that section, they're just saying you filed a supplemental claim. We acknowledge that you filed a supplemental claim. You met the requirements by sending us new and relevant evidence. We're going to reconsider it. But then they go into the reasons why they denied it. So you're kind of whiplash, like you did what you needed to do, but it wasn't enough. So your claim was denied because the evidence does not show you are unable to secure or follow substantially gainful occupation as a result of your service-connected disabilities. Cookie cutter, a little bit repetitive. We just read that. We understand it's denied. And they do cite the sections in the Code of Federal Regulations. And so if you want to go in there and pull those up, sometimes you get more information about what they think they're relying on in their denial. It tells you what date they received the form, the application for increased compensation based on individual unemployability, and when you reported that you last worked. So they're getting into some details from the specific claim. We asked for evidence to support your claim. They're saying we asked for evidence from your former employers. We didn't receive all of that evidence. We received a response from one of your employers, and this document does not show a reason for termination of employment related to disabilities. They're picking apart the evidence they have and giving their reasons why that evidence doesn't support the claim or why they don't think that evidence supports the claim. Now, take all of this with a grain of salt. These denials, a lot of them are kind of cookie cutter. And so just because they say evidence wasn't sufficient, or that just because the employer didn't give you this answer, that may not always be a valid reason for denial, but it's the reason that they are giving you for their denial. So kind of keeping the two thoughts separated of this is the reasons why they're giving me. Separate question is that reason valid? And for the purposes of this episode, we're just looking at how to understand the reasons that they're giving you so you can understand your appeal options a little bit better. So then they go into what was noted in the examination from the VES exam. VES is one of VA's contracted exam companies. So you go into what they noticed. And here they say that the veteran would excel at sedentary job, would excel at a job more sedentary with the ability to take regular breaks as needed and no timeline on when tasks are completed. So to me, this is raising some some concerns about their rationale for why they denied unemployability, because there's some assumptions that the examiner made that may not align with reality. And again, we're not going into the merits of this case, but they're giving you that rationale that gives you the foot in the door to make arguments about why their rationale is not supported by the facts, or why their rationale does not align with the laws and the regulations in place. It says we've reviewed both economic and non-economic factors affecting your ability to secure and follow substantially gainful occupation. And they kind of go into their rationale a little bit more, not so much specifics, but they're trying to align their rationale with the regulations that they're citing here. So again, you can pull those up and see if the language they're quoting really does match what's in the regulation, and whether that aligns with your facts. So here you've got a few paragraphs here that are kind of, and this is actually a pretty detailed denial. Sometimes it's a little bit more cookie cutter than this, and it's hard to pick apart. They're trying to just use, often we see them use template language that doesn't necessarily align with your records, or give you enough detail to really sink your teeth into what the decision means or how they came to that conclusion. But what I did want to point out underneath kind of the rationale for the denial, and it's not in bold, but it says favorable findings identified in this decision. And VA is required to identify favorable findings when there is ultimately a negative decision on a claim. And so those favorable findings are elements of the claim. So something that speaks to a current disability, something that speaks to something that happened in service. In this case, we're talking about unemployability. So is he unemployable? So I'll read their findings. You are not working. So that's a favorable finding, because in order to get unemployability, you have to show that you're not substantially gainfully employed. There's a lot of nuance into how to prove that claim, but that's one of the elements. So he's not working. He meets that requirement. The other favorable finding, your service-connected disabilities meet the scheduler criteria for entitlement to individual unemployability. So typically on TDIU cases, you need to be either have a single condition rated at 60%, or multiple conditions that combine to 70% with one condition at 40%. There are some exceptions to that rule, but they're saying that he meets the basic requirements for VA to consider him for unemployability. He's not working, and he's got disabilities that meet those scheduler requirements for consideration for unemployability. So with favorable findings, those are binding. VA is not allowed to overturn those favorable findings without showing clear and unmistakable error. So you don't have to relitigate the fact of whether he's working. If you file appeal, VA's already acknowledged that part. That part's done. So that helps narrow down the pieces of the claim that we're working on. So with this one, it's pretty obvious that from reading and picking stuff apart, that VA acknowledges that he's not working. VA acknowledges that he has service-connected disabilities that meet the scheduler criteria, but they don't think that those service-connected disabilities are the reason why he's not working, or the reason why he's not able to work. And so now that the appeal that we would work on from here is figuring out whether that's true, and what evidence we can develop to show that his service-connected disabilities do in fact prevent him from working in substantially gainful employment. So it's kind of VA's laying the breadcrumbs for us to follow to pick up what they think and why they think there should be denial. And then that helps us narrow our focus on our appeal. We're not just throwing stuff against the wall and saying, VA got it wrong, try again. I mean, you can file a higher level review and just say, please look again. That's all that's required on a VA form 200996, is identifying the decision that you want VA to reconsider. But if you can get in there and pick apart why VA made that decision and where they got something wrong, either on fact or on law, you're going to be in a much stronger position to help guide VA towards making the right decision, or figure out, hey, maybe they're missing some evidence that would have helped them make a different decision. And maybe we want to go back and gather that evidence, develop that evidence to show VA that the actual facts are different. Of course, you might look at this and say, okay, well, I didn't know that for the one where they rated him 30%, I didn't know that you needed to have those symptoms to meet the 60% criteria. And I just don't meet the 60% criteria because my symptoms aren't that bad. It might be enough evidence to let you know to drop a claim if your symptoms or if the facts of your case don't align with that higher rating. They're letting you know why they made that decision. And maybe they're right. The VA is not always wrong. We work on appeals, so our focus is the times when VA does get something wrong. But maybe they are explaining to you why they made it right, and that's the evidence or the information that you needed to let the claim go and say, okay, yeah, that one doesn't apply to me. I'm not going to keep pursuing that claim. But if you know where to look in the decision, you can understand what pieces VA might have gotten wrong, and it's going to help inform your appeal options. And that's what we do all day, every day. So if looking at this is making your head spin and you don't even know where to begin, even after kind of going through and picking this apart, then reach out to an accredited claims agent, an accredited attorney. We'd always be happy to take a look at a rating decision. And even if we end up not working together, we're happy to help steer you in the right direction and help you understand what is in the rating decision or what's missing from the rating decision so you can understand your appeal options better. So I hope this was helpful, and please put any comments or questions in the comment section below. We look forward to hearing from you, and stay tuned for the next episode.